the council members that are in attendance, as well as staff members that are present. Our first matter on our agenda is approval of the minutes of the previous meeting, that being September 12th, 2023. I know they've been disseminated. I would ask for a motion or any discussion on them.
Move approval.
Motion's been made by Mr. Gagnon. Is there a second?
Second.
Seconded by Ms. Hall. Any discussion? All in favor, say aye.
Aye.
Anyone opposed? The motion carries. The minutes are approved. Subcommittee reports.
Yes, Mr. Chair, the Planning and Procedures Subcommittee met earlier today to discuss some changes to both the Red Book and the management procedures, at which time PMP decided and allowed rulemaking to begin on three sections of those two programs. The first being section 650 RICR 20-0-1.1.13 violations and enforcement actions, as well as section 650 RICR 10-00-1.4.15, the administrative penalty matrix. In addition to that, the subcommittee allowed rulemaking to begin on changes to management procedures section 650 RICR 10-00-1.5.12 permit extensions. With that subcommittee's approval, staff will begin the rulemaking process in accordance with the Office of Regulatory Reform and the Secretary of State's office.
Thank you. Any questions of Mr. Willis on that report by the council?
I'll work with.
All right, staff reports, anything separate on the staff report?
I do have one report to call out to you. Last meeting, I mentioned that the CRMC, in conjunction with Sea Grant Coastal Resources Center and a couple of others, we held a walking tour down in East Beach in Charlestown to visually explain the shoreline lateral access legislation that was passed by the legislature this past June. About 100, or if not more than 100 folks attended that walkthrough, both public that are interested in shoreline access as well as private property owners. It was very well attended. The questions that were raised and answered were very respectful of the process. It was a learning event. It was very educational. And we felt that this being the second such type meeting that we had has gone a long way for the CRMC in meeting the requirements of the act that CRMC and DEM and the Attorney General educate the folks on what the shoreline lateral access legislation is intended to do. We're very successful in that. We were very happy with the turnout. We're very happy with the type of questions that were asked and answered, and we'll be holding more of these walks as weather permits, as well as holding additional meetings with town administrations and municipal police departments so that we're all on the same page in how this act is interpreted as we move forward, especially now in the off season, so that we can prepare for next summer season. So a very good event. I just want to let the council members know how well it was received.
Thank you. And piggybacking on the shoreline access comments by Mr. Willis, I'm going to ask Attorney DeSisto to bring the council up to date on legal issues regarding that.
A lawsuit was filed in federal district court here in Rhode Island by a group called RIAC in regard to the shoreline access bill. The three defendants in the case were the Attorney General, Jeff, and Terry Gray from DEM. That case has been dismissed by the federal court. However, this week we learned that another group has come forward. They filed suit in Washington County Superior Court. The defendants in that case are the state of Rhode Island and the Coastal Resources Management Council. We have a copy of the complaint, but the service has not been perfected yet. Case is not ongoing. The Attorney General is aware of the case and will be taking the lead in that case as they did in the prior case. We'll keep you updated on how that goes.
Thank you. Any questions relative to the reports from Jeff or Tony on that issue by the council? Okay, seeing none. Anything further?
No,
Staff report?
no, Mr. Chair, there's no further staff reports.
All right, bring us to the first matter on the agenda is ratification of a third-party environmental inspector. That's 2021-06-029 Revolution Wind LLC. The parties present here, I see Attorney Main.
Yes, Mr. Chair, we're here.
All right, you can come forward. And Justin, you have this one,
Yes.
correct?
Am I okay to present from here?
Yeah.
All right. Hello, good evening, council. Tonight for you is ratification for stipulation M of the environmental compliance monitor of the Revolution Wind project that was approved by the council. Part of the assent was to have our applicant get an environmental compliance monitor. They've submitted their package to us that show demonstrating that they have found qualified people with relevance to offshore wind projects, especially with cables, and pipe installations such as with horizontal terrestrial drilling at shore. This is the third party. They've included, which you've also have a part packet, a new fishery representative, different from the original packet. Person's also qualified. And this is the second part. We've separated these two at the request of the applicant from an uplands portion, which is more wetland for this one. The staff recommends ratification of this package.
Any questions of Justin from council members? Hang on, Attorney Main.
Yes, thank you. Good evening, and thank you again for your time on Revolution Wind. And thank you, Justin, for going over all that material for us. We're here tonight, as Justin noted, under two provisions in the Category B assent that the council provided to Revolution Wind at the end of last year, early this year. One is for an offshore environmental compliance monitor. If you remember back at the end of June, we talked about the onshore environmental compliance monitor. Tonight, we're here for the offshore piece. And we're also here, as Justin just noted, for the fisheries representative. With me tonight from Orsted in the navy blue jacket is Ross Pearsall. Ross is the fisheries relations manager for Orsted, and he'll introduce our proposed fisheries monitor in a moment. And I'd like to introduce ERM, which is the firm that we're proposing to do the offshore compliance monitoring, really the in-water type work monitoring. And I want to apologize tonight on behalf of Amanda Zuniga. She's an Orsted representative, and it's almost like you read about. Her plane was delayed, and then it was delayed again, and then the captain timed out. So she was not able to get to Providence on time. She apologizes, but again, I am introducing you to our two ERM representatives, Lindsay Colburn and Melissa Pierce. And without further ado, Lindsay will give a brief description of the proposal from ERM to do the offshore work.
Thank you for having us tonight. My name is Lindsay Colburn.
Before you start, please raise your right hand.
Oh,
Do
absolutely.
you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell it for the record.
Absolutely. It's Lindsay Colburn. That's LYNDSEY COLBURN. As I mentioned, I'm Lindsay Colburn. I'm a partner with ERM. I've been with ERM for over 17 years. ERM as an organization has a long history of supporting clients in the energy sector with all types of permitting, all types of compliance monitoring support. My role on the project will be to ensure that we are responsive to CRMC, that the monitoring that you've requested, the reporting that you've requested is done on time and to the level of detail that you expect. As a consultancy, ERM also has technical experts on hand to support each aspect of the offshore requirements of the Category B assent from CRMC, as well as the water quality certification. Our team includes consultants with experience in vessel safety and compliance, threatened and endangered species, archaeological resources, marine and coastal zone management, as well as water quality and sediment control. We can combine the global footprint of ERM and our subject matter expertise with our local presence in Rhode Island to provide both strong technical capabilities as well as a deep understanding of the local and state stakeholders. We've recently supported other local offshore wind development projects where we worked for the Bureau of Ocean Energy Management to prepare their third-party environmental impact statement, as well as supporting ongoing offshore wind development with overall permit compliance. Right now, we're supporting a program managing over 2,000 permit requirements from local, state, and federal permits for another ongoing offshore wind development project. And our role is to make sure that all of those thousands of permit conditions are met. The ERM team has a strong presence, as I mentioned, here, right in Rhode Island and in New England. The team that's going to be supporting CRMC is based here locally. It brings many years of experience with both permit compliance as well as water resource compliance. Myself and the ERM team we're looking forward to supporting the CRMC teams, CRMC staff with this project. And with that, I'd like to introduce Melissa. Melissa Pierce will be our lead environmental compliance monitor for the project. She brings many years of experience and she'll be the eyes and the ears on the ground for CRMC. So I'll turn it over to Melissa to say a bit about herself.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell it for the record.
Melissa Pierce, MELISSA PIERC. Hi all, my name is Melissa Pierce. I'm a principal consultant with ERM. I'm based in Riverside, Rhode Island. I've been with ERM for 12 years, and over those years, I've supported clients across various industries with their permit compliance. I also come from a maritime background. I graduated from Massachusetts Maritime Academy with a Bachelor of Science in Marine Engineering and a U.S. Coast Guard Third Assistance Engineer's license. And like Lindsay said, I will be the eyes and ears on the ground, an extension of CRMC. I will provide all necessary reports and be available to CRMC whenever needed. I look forward to working with the CRMC and just let me know if you have any questions.
That concludes the presentation by ERM, and then we can move on to the fisheries monitor.
Any questions from the council at this point?
I just had
As well?
just one quick question on the local team. So Melissa, the local team is you, and you have access to many others on the water in and around the site in terms of monitoring those thousands and thousands of permit conditions that your colleague mentioned.
Yes, I'll be the lead compliance monitor. I do have, support also, across CRM to help me, but yes.
With all the disciplines and areas of expertise that your colleague mentioned.
Yes.
We do have that team local, like.
That team is also local?
Yes, we have an archaeologist and a marine mammal observer locally, so we can have, depending on the nature of the task at hand, we can have subject matter expertise to support Melissa very quickly.
Thank you.
And Ross, would you introduce next?
Sure. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell it for the record.
Adrian Ross Pearsall, ADRIANROSSPEARSALL, and I do go by Ross. Anyway, thank you for having us tonight. We really appreciate your time and hearing us present both of our experts. As Robin stated, my name is Ross Pearsall, I'm Morstead's Fisheries Relations Manager, and I'm here to propose Max Hall as the fisheries rep. Max has been a member of the fishing industry since 2012, working on a bottom trawler out of Point Judith. Recently in 2021, he took it upon himself to found his own consulting firm to help offshore wind developers liaise better with the fishing community. Since Max is here, I can have him give you a little bit more of his background, but and you do have his resume in your packet, but he's a Rhode Islander, been here all of his life, and is well known by the fishing community. And maybe most importantly on the resume that will not come out in the fishing aspects is that he is an Eagles fan. So with that, I'd like to hand it over to Max. And
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do, yes.
Please state your name and spell it for the record.
Maxwell Hall, Maxwellhall. Thank you. I've been a commercial fisherman for the last 10 years in Point Judith, Rhode Island. I've worked closely with the fishing community the last 2 years, and I look forward to working with the CRMC. Thank you.
That concludes our presentation for this evening on the ratifications.
Any questions of Mr. Pearsall or Mr. Hall from the council? Oh, okay. Anything else from you, council?
That concludes it. Thank you.
All right. Anyone else present on this application? No. I'm gonna ask them. Anyone else present this evening on this particular application? We'll make sure.
But I just, I can't go, one question.
Of course you can.
Question. You've got a 59-page thing in front of me over here. There was this, is it Craig Shadier? Is the environmental archaeologist?
Correct, yep.
You know, that's the one that kind of, what is it? And I understand that when we put in the other wind farm off Block Island, that we went through that, had to work with the Native Americans and did some surveying out there. Is it the same approach here? Is that, what happens with this guy?
Well, let me just say this. We've already done those surveys that you're referring to for Revolution, and ERM's role is to report back to CRMC to make sure that we're staying within the approvals that we have, some of which touch on archaeological, for example. And Lindsay, would you like to add to that?
So this person reports to ERM or works for ERM or what?
ERM will report to CRMC on the topics that CRMC wants to hear about and at the frequency CRMC wants.
Okay, that was another question I had, the reporting communications, but on the archaeologist, he is a certified, so he's a consultant with ERM.
Part of the bench that they bring.
And you've already done some work in that area.
Oh, we've done extensive work in that
Okay.
area.
All right, thank you.
Any further questions of the council? At this time, is there a council member in a position to make a motion? And I think the application or the hearing this evening is for our ratification of third-party monitor and inspector. So that's, am I correct?
That's correct, yes.
And the fisheries rep.
And the fishery representative as well. Anyone want to make a motion? Ms. Hall?
I move that based on what we've heard presented this evening regarding the qualifications of ERM to serve as proposed third-party environmental inspector, as well as the proposed fishery representative Maxwell Hall, that we, what is the language you're looking for? Agree, affirm,
Ratified?
ratify the appointment of those experts.
Thank you. Is there a second? Seconded by Mr. Gomez. Any discussion? Having none, I will poll the council. Mr. Russolino?
Aye.
Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
I too, Raymond Coyer, vote aye. So the vote is 6-0 to ratify. Thank you.
Very much. Appreciate your time this evening.
Next will be the applications that have been out the public notice before the council for review and action. First one being East Meadow LLC. Bearing number 2023-01-019. It's an application to construct and maintain a residential boating facility consisting of a 4-foot by 120-foot fixed timber pier, 3 feet by 18 feet access ramp, and an 8-foot by 18.75-foot terminal float. The facility is proposed to extend plus or minus 90 feet seaward of the cited mean low water mark as measured from the inland cited mean low water mark on the western side of the existing sandbar. The structure is proposed to extend 33 feet seaward of the outer cited mean low water mark on the eastern side of the existing sandbar. The project is located at plat 88-4, lot 6 at 1391 Succotash Road, South Kingston, Rhode Island. And I see the applicant is present. Sir, if you could identify yourself for the record, please.
Kelly Fracassa, I'm the attorney for East Meadow LLC.
Can you spell the last name, please?
Sure, Fracassa.
Thank you. Before you present, we're gonna have our staff give the summary to the council, and Tracy Sylvia's got this one for us.
Thanks, Mr. Chair. As stated, it's a residential dock application. It's in Point Judith Pond in the Succotash Snug Harbor area. Property fronts both Point Judith Pond Channel and the Potter Pond Channel. It's in type 5 waters, mostly facing east. There are a few homes located at the top of the peninsula. There's an existing residential dock just to the north of the site, and there's a sandbar out in front of these homes, which makes it a little unique. Standard 150 square foot float, as stated before, 40-foot length variance. It also needs 100% variance for crossing over the northern property line extensions. Staff issued a PD a couple years ago, commenting on the facility and recognizing that its original proposal at 5-foot water depth, which was kind of centered on the lot lines and didn't require as much variance to the north, did require variance in the south, and it was pretty long. So we recommended shortening it, moving it to the north, which they did. This application came in, we sent it to notice. There was one objection received from the abutter. It meets the channel setbacks. The Army Corps has issued on it. And as far as the variances, staff supports the variances, has been objected. We believe it's consistent with our comments for the siting of the facility due to its length, due to the depth at terminus, due to the sandbar it needs to cross. And if we move it to the south, it would just increase those variances and or add additional variances. As far as the aesthetics, staff believes it's similar to existing uses. There's marinas, Galilee Fishing Port is nearby. There's other docks. The one objection we did receive had numerous concerns, and the applicant's attorney responded to those. Staff concurs with those relative to the site conditions. And so we defer for consideration of the objection. Standard stipulations would be prepared if the council chose to approve.
Thank you. Any questions of Ms. Sylvia from council members at this point? All right, Councilor. Oh. Someone have a question?
Yes.
Ms. Hall.
So under the, your review of the project, given all the facts that you just stated, specifically with respect to the objection, would you deem that objection substantive?
I don't believe that's my permit staff role to decide. I can be corrected on that topic. But as far as it's a typical objection that we do receive for dock applications from nearby neighbors concerned with its impact on view and use and existing uses. I don't see a technical reason why that objection should stop this dock
permit.
You know, I'm just wondering about evidence presented. Because I mean, you know, we don't know about proposed activity or alteration potential for significant adverse impacts on the coastal environment under this rule 1.1.6 G. So all those, you mentioned some of the scenic recreation and activity along the shore, but I was just wondering, based on the facts of the record as your expertise, does the objection present evidence that demonstrates that that activity would have a potential for significant adverse impacts? You don't believe so? Thank you.
Thank you. Any other questions at this point? Seeing none, Counselor, please.
I was just going to introduce some additional evidence into the record, just some deeds and just a few other photographs, and that was about it. I'm prepared to do it by way of testimony.
Yeah, here's the thing, there's a kind of a deadline to get evidence in. And that's for the benefit of the council, so they're not reviewing evidence at the time of the hearing. You could certainly use them, however, in the course of your testimony as to bolster that testimony.
Okay.
So why don't you start questioning the witnesses? Which one's first?
Paul Hooper.
Mr. Hooper,
Yes.
raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and spell it for the record.
Sure. Paulhooper.
Mr. Hooper, you're a member of East Meadow LLC, is that correct?
Yes.
Right, and East Meadow LLC took title to 1391 Succotash Road in South Kingstown, is that correct?
Correct.
All right, and you took title through 2 deeds in November of 2019, is that right?
I believe so, yes.
Okay, I'm going to show you 2 of the deeds. Do you recognize them?
Yep.
Okay, and if you could go to the second page of either deed.
Yep.
And each of those has a description of the land, is that correct? Actually, it's the third.
No, it wasn't on that one.
I screwed up. All right, and the property referred to is Lot 2 on a certain recorded plat entitled Plat of Gooseberry Island in Point Judith Pond, Town of South Kingstown, RI, property of William A. Phelan, August 1944, Leon Holland, civil engineer. You see that there?
Yes.
All right, so you took title to a piece of property which was platted in 1944, is that correct?
I believe so, yes.
Now, just some other photographs here. Now, this property that you have, you're familiar with that channel, is that correct?
Very well.
All right, and you're familiar with it because you piloted boats in and out of it, correct?
For some 50 years.
50 years? And what kind of boats have you piloted in and out?
30 footers right down to the 16-foot dogger, which is a skiff.
Okay, and that's your son's boat, correct?
Yes, it was.
And what do you intend to do with this dock?
Well, I think we have numerous boats. I myself have 4. My brother has 3 or 4 himself. So we have lots of boats for different applications, and we use that to move the boats.
Okay, how many boats?
Probably 2.
Sizes?
Well, the float is a certain distance. It wouldn't be any longer than the float, I believe. And if the water allowed to put one on the inside.
And how long's the float?
Boy,
Just roughly.
is it 20,
Okay.
19, 20 feet?
Okay, so you intend to put boats which are around 19, 20 feet.
Right, I have a 21-foot craft that would probably be there.
All right, and how often have you piloted boats like that?
Since I was probably 10 or 12.
Okay, so you've been out on those thousands of times, is that correct?
Yeah,
All right,
sometimes not back.
All right. And you've piloted those kinds of boats in and out of that channel, which
Yes.
goes right around that corner in front of the Keaton property and your property. Is that correct?
Correct. The Hoopers have 2 or 3 properties west of there.
All right. And you've gone in and out of there
Yes.
innumerable times. Is that correct?
Yes.
All right. And any difficulties getting out? Any concerns about navigating that particular channel?
No, it gets a little tight further up west, but that's where it starts to open up and the water slows down.
And tell us about your experience in docking at this type of a pier and navigating away from.
It's usually not a problem, especially further towards Seward Harbor Marina where the water slows down.
And how many feet do you need? I mean, I'm not a seaman, as you well know. How many feet do you need to maneuver a boat into a dock such as this?
Well, it depends on a lot of conditions, the wind, who may be approaching you, but usually it's not very difficult. There's times depending on the weather, you would go into the flow of the water. That way you control your speed. Sometimes when you go with the water, it's tough to control your speed. So it's one of those things that you deal with it daily.
And your dock is, you have an understanding as to how far your dock would be from the Keaton dock?
From the drawings I've seen, 60 feet.
And what, if any, difficulty would you encounter docking a boat that you intend to moor at this pier? And what, if any, issues would you have with the proximity of the Keaton dock?
There shouldn't be a problem, and usually boats coming down through the sluiceway there have the right of way with the tide. Because you can't control yourself. You can control yourself going in, but there's plenty of room there to manage someone coming down through where the ramp was. So you would just be smart. Take your time and wait.
I'm gonna show you a photograph. You recognize that?
Yeah,
What is it?
I took that from the next door neighbor's property of our house. We recently purchased, and recently the mud flats that's out in front of it and the channel further on the corner.
All right. And what does it show?
Shows the end of Doggy Beach, which is where, that's the end of the channel.
Okay, and we were talking earlier and staff was discussing about a sandbar. Do you see that sandbar there?
Yes,
All right, bird's eye view of it, correct?
yes,
All right, you see also other docks on the other side of the channel, is
Yes.
that correct? And does that photograph fairly and accurately depict conditions as they currently exist?
I would say yes, and that looks like it's at low tide where the flow would be the greatest.
Council, is it proper to introduce this photo?
No,
Okay. I'm gonna show you another photograph. Do you recognize that?
Yes,
Tell us what you see.
that's an aerial photograph of the looking from the west to the east. A boat's coming around the corner from Point Judith Marina, it looks like. And it depicts the channel
All right,
and the sandbar.
all right. And do you see the Keaton dock there?
Yes.
Okay. And tell us what's on the other side of the channel from the Keaton dock.
There's 1, 2, 3 in close proximity of the channel and the Keaton dock.
Can you estimate the distance between those docks and the Keaton dock?
Oh, boy. I would say, I'm just taking a guess,
Well, don't guess.
60, 70 feet, I would think, floats 20, probably be 80 feet maybe.
I have no further questions of Mr. Hooper.
Any questions of the witness from council members at this time? Okay,
We also have Mark Dowdell here, who's the engineer who put together and filed the application. If he has anything further to say, any presentation, I'll just let him take it away.
do you, Mr. Dowdell?
I don't have much to say.
If you do, I'll swear you in.
Sure, yeah.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and spell it for the record.
Mark Dowdell, MARKDOWDELL. As Tracy had kind of explained, this dock, you know, we have quite a few constraints, but you know, as far as the application itself, you know, we were minimizing all the possible variances we had to go for to basically get this float out toward the channel. And you know, this design kind of gets to that point as best as we can. And you know, that's the main reason for this property line extension crossing and the length variances. And it was basically the minimum we possibly could have against these variances. So that was pretty much all I wanted to say.
I just got a couple of questions.
Go ahead.
Mr. Dardell, do you know how far the proposed East Meadow dock would be from the Keaton dock?
About 60 feet.
Okay. And I'm going to show you the photographs which Mr. Cooper was discussing here. That photograph, you familiar with what it shows?
Yes.
All right, you see the Keaton dock there?
Correct.
And you see the docks across the channel?
Yep.
All right, can you estimate the distance between the Keaton docks and those docks?
Well, I
Just
can.
roughly.
Yeah, it is around 60 feet. I would probably say 60 to 70 feet.
Roughly the same distance between the Keaton dock and the proposed super.
Right.
Is that correct?
Right, correct.
Thank you.
Any questions of Mr. Gomez?
Yeah, I may have missed something, but it looks like staff had suggested that you talk to local harbor masters. Did you do that?
Yes.
Were there any problems with that?
The application went before the South Kingston Town Council of the Waterfront, which is Mike is the harbor master. And he looked at the plans twice, and I asked him if he had any navigational issues before going forward, which would be smart on my behalf, and he said no.
Okay, thank you for that. And just one last question. The selection for the 5 foot at low tide. Oh, why? I understand that CRMC rigs on something like that either want to walk over the dock or walk under the
5 foot
provision. So you have a 5 foot provision. Is that, where is that 5? Is that the end of the dock? It's out over the sandbar, right?
Between the fixed pier and the.
It said low mean tide.
Yeah.
5 foot separation
between the, you know, mean high water and the bottom of that.
It's between high water and the dock.
Between high water, that's what the rules state.
Is the 5 foot.
Yes.
Okay, I've read it as low water.
Yeah, it's to, you know, allow for lateral access and, you know, obviously provide that freeboard. You know.
Understand, I got it. I had a little wrong. Thanks.
Mr. Chair, to clarify.
Yes, Tracy.
The original proposal was the length was out to -5 water depth, which was shortened to -3. And there is a 5 foot height clearance at the mean high water mark. Lateral access.
Okay, thanks.
Yeah, I'm sorry, I misinterpreted what you were discussing.
It's fine.
Okay.
Any further questions of Mr. Dodell? Please proceed, sir.
I have nothing further.
Okay. Is there anyone else present this evening that wishes to speak in favor of this application? Is there anyone present this evening that wishes to speak in opposition of this application?
Good evening, Mr. Chair. Director Garabedian and I represent the Shirley Trust, the objective.
All right. If you guys can go back and this attorney, the table.
Good evening, Mr. Chair and members of the board. As I indicated, my name is Jeffrey Garaginian. I represent the Shirley Keaton Trust, which is the abutter and the objector that are here. With me, I have Tammy Jones, who is a family member and owner of the trust. And also Richard Pastori, who will provide some testimony as well with regard to a review of the information. Our position here tonight is obviously we're not objecting to the creation or the implementation of the dock. Our issue mainly at this point is the location. As you know, as you can see from the pictures, the dock and pursuant to the variances that are being requested crosses directly across the on water property lines, directly in front of our client's property. It's our position that that's not the least restrictive use, that this dock should extend straight out instead of north towards our property. And I think it's clear from the diagram as to how this is going to go. And again, as my brother said, I'm not a seaman either, so I think most of the technical issues in the details with regard to that, I think Mr. Pastori would be better able to provide information to the board. So Richard Pastori here.
Mr. Pastori, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and spell it for the record.
Richard Pastori, Pastori. For the record, counsel, I'm a registered PE in the state.
Please proceed.
As Jeff has spoken to you about, I think the major issue, well, let's Paul already told you about the current that's going out through the gut over there. My client's dock already exists there. Paul's been on the water a long time. I've been on the water since I was 8 and I'm 73. So I outpace him just a little bit, but anyways. And I've got a 28-foot boat for 20 years. 63 feet between those two docks in bad weather, in bad current, in wind. You can make a mistake and you can very quickly have this proposed dock, if it gets built, have it be an issue in trying to dock. We have a problem with the 63-foot separation. There's also the current, as Paul has told you about, comes out of that gap, which can also complex things. However, I think the major issue here is that, and one thing perhaps staff can explain to me is what seems to be a threshold of minimizing variances in the construction, in the configuration of the dock. Paul's property has a sandbar. I know Dog Beach very well. And in order to turn the dock the way they proposed it, it does shorten the dock, but it's basically, it's a bit of a taking, if you want to use the term, and I'm no lawyer, on my client's property. If they should want to put another dock on their property, if this dock gets destroyed, if they want to move it at all, and they want to move it further out where there's less current, where there's less issues in docking, you've kind of encroached on their right to do something within their own riparian area. I was looking at if the dock on Paul's property came straight out and stayed within their property lines, and if you'd like, I have a little diagram you can look at to see what I'm talking about. If it's allowable, counsel, I have one for you. If you extended that dock out probably another 40 feet, you could get to the 3 feet of water you need to dock your boat, and you could stay well in front of Paul's house, and you could be very clear of my client's property. So, I mean, in a nutshell, that's basically it. I don't understand the minimization of the length of the dock and or the minimization of the number of variances, which this council could easily grant. There's certainly reason to do that. And again, I agree with council, that our council, that Paul has got a perfect right to put a residential dock on his property. By the way, just out of just for fun facts, there's about 53 million cubic feet of water that passes through that gap on one tidal cycle. And it comes out to about a 5 foot per second flow rate. And that's just a kind of a general number I played with the other day, just to see what would happen. But anyways, so we would certainly appreciate your consideration to keep Paul's dock more within line with his property than to encroach on my client's property, because it shuts down a considerable amount of use for my client's any future potential use for him.
Any questions of the council, by the council, Mr. Pastore?
Yes, sir.
If that, your proposal was accepted, would the objection go away?
I'm sorry?
Would you, dismiss the objection?
You know, if I'm going to speak for my client, I would say yes, I would, but it's up to them, and Jeff would have to ask them. But there'd be no reason to object to it then. I mean, I think everything would be fine, but yes, it would.
And yes, we would withdraw the objection if the dock was modified, if the plans were modified to.
And I believe that what CRMC had done was to try to minimize the size of the variance, if you will. Is that correct? To reduce the amount of variance that we are looking at.
Sure. And Tracy can add to this, but CRMC policies are to minimize the use, in this case, the structure, to the minimum necessary. And staff worked hard to look at that, and it also looked at the variances and opposed to what the original request was, but looking at the structure and its impacts to the coastal resources, we try to just minimize that structure's impacts. So that's what staff was working towards, and I don't want to speak for Tracy. She can add to that if she wanted to, but that's one of the reasons why the configuration is proposed this way.
Correct. Staff looked at a few things. First, the centering it would require sign-offs from both abutters. It was unclear at the time whether there would be an abutter sign-off to this side, regardless. It was already encroaching on that side. Also, the shorter crossing of that sandbar is heavy recreational use on that sandbar at low tide by members of the public that just bring their boats there. So that this design, was one of the options where if we lot 5 to the south came with the dock in the future, they could go, perhaps further south, and you'd have a larger area of sandbar that was not fragmented, I guess. And then the length variance is, significantly increased if you enter it.
So in fact, you've got a public use issue if you link the dock.
There is, and I mean, I don't vote there, but.
No, I mean, from the sandbar standpoint, I think you.
Yeah, I mean, you could put a kayak around wherever you put it, but yeah, I think trying to keep one section open versus another. But do I think there's significant environmental impacts to either of those design choices? No.
With the proposed change, would you be in favor of that or not? I understand you spent a lot of time trying to, cut the baby in half, so to speak.
Right. I mean, if the variance criteria is deemed met and the minimization is one of the criteria, that is.
But you don't see it as impacting, you don't see the proposed change impacting public use of the sandbar and things.
I mean, you can still use the sandbar.
Yeah. So there is no public impact if we did that. Is that?
How significant it would be, I don't have direct evidence of that. I didn't look into that further. It was just trying to maximize what was left.
Maybe just something to think about.
Not fragmented.
Well,
If I may, can I speak, sir?
Yeah.
First of all, I raft up with my boys on Dog Beach all the time. You can't, the sandbar is exposed at low tide, so you can't anchor there. So it's merely, it's pedestrian traffic if you want, or dogs running and kids playing. So that's not really a big deal. There's also in the regs, there is something that speaks specifically to use conflicts. And use conflicts, Tracy certainly pointing out public use versus where the dock, the size of the dock. But there's also the use conflict of the neighbor who has the right, like I spoke of, and I won't beat a dead horse about the whole.
It doesn't work out. Yeah, are there any other council members that has an opinion along the line of a change or as originally proposed? I guess I could be convinced either way.
Yes, Mr. Gagnon.
So, question for Mr. Pastore, if the dock was moved, say, 10 feet away from your client's dock, and you gave you 70 feet versus 60 feet, is that an improvement? Is that not worth the effort, or?
Ron, I don't think it makes that much of a difference, 10 feet. I mean, you're still encroaching on my clients' riparian areas. I think, and there's no reason why you can't keep it within both riparian areas either. I mean, granted, the dock's gonna be longer and all, but I perhaps don't give as much weight to that as Tracy does. So moving it 10 feet, I've got a 30-foot boat, and 2 lengths of the boat in bad weather is not a lot.
Do you live there in this, you're not related to them? Your 30-foot boat's not related to this, is it?
To whose, ma'am?
Is your 30-foot boat part of that family's?
Oh, no.
Okay, I just was wanted to be clear.
No, we're not related. We were just talking about boat lengths and docking prior. Paul was telling you about that, and I just wanted to opine a little bit on it.
Legal counsel question. Can you address Mr. Pastore's assertion that there's some takings at issue here relative to this client? Could you please address that for us?
Well, as Mr. Pastore said, he's no lawyer. And I actually think the term takings is misplaced here.
Okay.
On it. I'm assuming that you're referring to the riparian rights.
I'm referring to a diminution of the use of the riparian rights for the client in this proposal if it's built. If you don't consider that a taking, that's fine, but that's what I meant.
Okay. Can you elaborate on the statement, there's a diminution
Right.
of the riparian rights?
Right. The way the dock is proposed, do you agree that it's within the riparian?
I don't agree to anything. I want to
Okay,
hear what
then
the
I'm-
diminution is.
And the way the dock is proposed, it's within the riparian rights of my client's property. Therefore, if the dock is built, they can't use that area of which they are granted, to which they have rights to use. That's what I'm referring to. If they wanted to put another dock in, they would now have to be concerned with where this dock is, which is technically within their riparian way, and they would have to adjust themselves. So I'm saying that if everybody stays on their own property, it makes a much better solution.
So you're saying the dock intrudes on the riparian right line of your client?
No, the riparian right line defines a riparian area, and I'm saying it intrudes on the area. It crosses the line, granted, counselor, but it is in the area that is the riparian rights of my client.
Thank you. As a matter of Rhode Island law, that's not a taking.
Thank you.
Mr. Chair,
Yes.
Riparian rights, if you will, are decided by the courts, not by the agency. The agency, by practice and by regulation, looks at a dock's placement between the extension of a property line out into the water. When we're talking, this one starts in that area, if you will, and then veers based on work with staff and the proposal. If there were riparian rights to be determined, the courts would have to look at the navigable waters. And in this case, there are no congressionally authorized channels here from which you would draw your 90-degree riparian lines into the property. So when we're talking riparian rights, I think we shouldn't because they haven't been established here. And what we should be looking at are impacts to Rhode Island's coastal resources relative to the dock's design.
That's a correct statement, but I did want to address this question of a taking. And the answer to the question is it's not a taking. Jeff is correct when it comes to riparian, that is a court issue. But as to the issue of whether or not this would be considered a taking under Rhode Island law, the answer is no.
And by connection to Chair Willis's statements, it also is not impugning a riparian right because there have been no riparian rights established.
That's a fair statement, yes.
Okay, thank you for that clarification.
But it matches up. As proposed, it matches up more closely with the coastal resources, your management plan. Basically, the goals that you're looking for. And keeping it in unobtrusive.
Staff would look at any activity relative to the requirements to minimize the impact to Rhode Island's coastal resources.
Right, and that's why we have the plan that we have in front of us. Right?
That staff felt, given the constraints of the area, given the Rhode Island's coastal resources, given the design, what the property owner is seeking, all those things added up to this configuration that the staff to get.
Good.
But to continue to support my client's ability to put a residential dock on their property. And I apologize for using perhaps the wrong language, Mr. Easton. But as you correctly point out, CRMC has rules. Otherwise, you wouldn't be asking for variances from riparian lines from property owners when you're within 25 feet of those property lines. So there is some right established for my client in front of their property between their extended property lines. Call it what you will.
We have had a number of discussions on riparian rights, especially when the cove is a cove that is like a semicircle and things. So we run into this problem often, and I think this is the discussion on the status of riparian rights, and your addition to it, Jeff, is what I accept, that there are no riparian rights in this situation. Is that correct, Tony? Yeah.
It's, I see Tracy raising her hand, but it's not a true issue in this matter.
I'm not gonna answer your question. But just to a case in point, when we're looking at these docks, the first thing staff does is say, okay, what do the other properties have? Do they each have a dock? If not, could they fit one in the future? That's how we're looking at these property sizes.
So it's a good compromise.
And the dock to the north has a dock, this lot to the north has a dock, you know, several going that way, north and west have docks. Ones to the south, and then you hit state property, you really don't have many more options that you would have there, but that's how we're looking at that shoreline. If you can stay within and minimize and meet our regs, then that's what we first try to do. This site can't do that.
Any further questions of Mr. Pastore from the council? Anything else, Counselor?
No, I just want to make some comments. I think that there's some information maybe it's being overlooked, but the sandbar we're speaking about here, there's no public access to the sandbar. It's not, and we keep saying public access. This is an island point where only the property owners can get to this sandbar. So by making the modification as proposed, we're going to limit my client's access. We're going to modify, and we're concerned about, you know, preserving the coastline. It's going to modify the use of this property. It's going to modify how things are being done there. And I know, and I understand the point, Mr. Wills, but it seems to me that extending the dock further out doesn't impede my client anyway. It doesn't prevent them from modifying their dock, which is going to happen at this point. If this proposal goes in place, they can't modify their dock. They're going to be stuck now because the neighbor is in their area. And I know, we've had our discussion with regard to the rights, but I think we have to look at the practical matter here, and we're going to minimize the use. We also, I think, should consider the impact on the area. My clients have owned this property since 1968. They've used it, they've had it, and it's been that way for a long time. And now this dock is going to come in and modify and completely introduce the area, and it's going to impede their ability to enjoy the property. It's going to impede their area to maneuver their own boats, as you've heard. I think there's an option here to put it in under the original plan, and I think that makes more sense in this instance. That's all I have. We rest.
All right, thank you. Is there anyone else present this evening to speak in opposition of this application? All right, seeing none. Attorney Fracassa, if you'd like to just come back up, if there's anything else you'd like to close with?
Just one thing, it sounds like the Keatons are trying to determine the design of the East Meadow dock based on a hypothetical as to where they may in the future put a dock of their own. They've already got one. They've already got a good location for it. So I don't think they get to force a modification, well, not force, but even cajole a modification based upon a hypothetical, which they don't even have before the council. But as far as the most important things, and we're talking here about issues of law regarding riparian rights, and just looking at the case law on this, Potter versus Crawford, which you're probably aware of, Anthony. And the big issue there was, yes, somebody did infringe on somebody's riparian line, but because there was no impact on navigation, the riparian rights of that owner were not infringed. And that's not unique case law. You're going to find that across the country. The big issue here is something which we all agree on, that the Hoopers have a right to wharf out. It's just what that right is going to look like. Now, we have a convex type of point here they're on. Their boundary lines go at a triangle like that, so they're trying to extend out into the water, and it's rather a huge slice of pie is what it would look like. Now, if their boundary lines were hypothetically straight on, there probably wouldn't be an issue here. But the big thing that the courts look at here is the impact on navigation, not where the riparian lines go, because it's less of a property right than they presuppose. The state owns this in trust for the public. It owns that land. Riparian lines are kind of like a quasi easement. In other words, that you can use the area within those lines for a specific purpose, namely to wharf out. The Keatons have already successfully done that. They have their spot, they have their boat. And the Hoopers here, yes, does it grow strictly across what the riparian's line is? Yes, it does. Does it impact their navigation? Not in the slightest. So it's for that reason that this is actually a non-issue.
Thank you.
The applicant gets the last word.
I understand.
That was the last word.
Okay.
Any questions of Tracy or Jeff from council members on this matter? Is the council in a position to vote or a motion? Mr. Gomez?
Yeah, based on the findings of fact, the discussion of we've had on the legality of the riparian rights in that area, and the effort by CRMC to best comply with the management plan, I would move the staff position be approved, and the noted standard stipulations, I'm not sure what they are, but standard stipulations apply. And there was one of the stipulation, the other stipulation would be the construction should not, there was a note in here relative to minimizing the construction impact on nearby property. There's a line in there somewhere that, so we would add that minimize construction impact for the standard stipulations.
Okay. A motion has been made. Is there a second?
Second.
Ms. Hall has seconded it. Any discussion? Hearing none, I will poll the council. Mr. Russolino?
Aye.
Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
I too, we require a vote. Aye. Application is approved. 6-2-0 vote. Thank you.
Thank you.
Next matter on the agenda is 2022-06-136 Point Break Realty LLC. It's an application to construct and maintain a new residential boating facility consisting of an upland ramp, a 4x62-foot fixed timber pier, a 3-foot by 18-foot access ramp, a 4x4 access landing float, and an 8 by 18.75 foot parentheses 150 square feet terminal float. The facility will extend 39 feet seaward of the cited mean low water mark. It requires a 25-foot property line extension variance, which is 100% to the east, parentheses Water Street, and west, which is assessors plat 93-1, comma lot 63 per Red Book 650-RMACR-20-0-0-01, section 1.3 D11K, located at plat 93-1, lot 67 at 20 Water Street, South Kingston, Rhode Island. And I see the applicant is at the table. If you could identify yourself, please, sir.
Sure. Good evening, Director Willis, Mr. Chairman, members of the council, Attorney Matthew Landry. On behalf of the applicant Point Break Realty, I'm joined by Kevin Finnegan, who's a member of the applicant LLC, and Russell Morgan, who's the PE who prepared the application and the plans before you.
All right, and I think Tracy, do you have this one as well?
I do.
If you could just give a summary to the council, please.
Sure, Mr. Chair. This dock, similar to the last application we just had, pretty standard pier ramp for the design, and it is situated in Potter Pond, southwest corner this area. The essential issues with this one is, again, property line configuration. It does not need a length variance, it's less than our standard. There's no wetland crossing at this time. It was modified several times in pre-discussion, during review, prior to public notice, so that it doesn't cross any current salt marsh. It does pretty much whatever you do out here, you're going to need a property line setback. It's just the way the line falls. So staff worked with the applicant's designer to avoid the wetland, get enough water depth, and keep enough room to the western abutter, again, for navigational purposes. The biggest issue is that when it went out to public notice, the town requested an extension to review it at their harbor commission meeting, and the town of South Kingstown objected. And they filed an objection, one, due to excessive length, which staff doesn't support or agree with. And second, due to impacts on the adjacent right-of-way to the east. The right-of-way to the east is not to date deemed a public right-of-way. It's allegedly privately held by members of the area. No other public comment was received during public notice period. And the town and CRMC policy are working on that status of the right-of-way. Separately, prior to this application, and will continue to do so. A sign-off was received from the abutter on the eastern side of the right-of-way, as well as an abutter to the north, which they also crossed. They did not get a sign-off from the immediate western abutter. Correct. So they would need a variance to cross that one as well. They did not get an objection either. So again, staff defers for consideration of the objection, but there's no technical and environmental objection to this design.
All right, so I have a question. I'll ask it a lot to either yourself or Jeff or Tony, whoever may answer it. When I review this, obviously one of the glaring objections is an asserted right of way. Is there any evidence documented anywhere of an existing right of way that's being alleged?
So, Mr. Chairman, we asked the town for their position on this matter, and you'll see in your packet some of the emails that went back and forth between myself and the town. Where the town is, if I can say, is aware of the historical regular use, but it's their understanding that the road is private. However, they have asked that the CRMC's Rights of Way Subcommittee perform an investigation to actually make a determination of whether the site is public. So it's in the Rights of Way Subcommittee queue. It has not gone through the public hearing process. It will, but we have no evidence, nor have we conducted an evidentiary hearing process to determine that.
Well, I see that the council member has a question.
May I ask a follow-up question?
Sure.
When you say, so first, whether or not it's a private road ultimately is not determinative of whether or not it has evolved into a public access point, correct?
Correct.
And when you say there's no evidence that there's public use in that area, it's that there's no official public right of way, not that there's no
That's
public
fair.
use.
That's fair.
Okay, so we have been presented with evidence, or we haven't been presented with evidence that there is public use in this area.
We've gotten several letters from residents in the area stating that they have used it, that it's always been used by the public, but that would be part of an evidentiary process to determine whether or not it is in fact public.
That would be determined if it's a
Public.
CRMC accepted public right of way, but not whether it is actually used currently by the public. It could be used by the public, but it hasn't gotten the
That's
designation.
That's correct.
So based on the evidence that we have of public use, my question is under Rule 1.1.6G, based on that evidence, would you consider Tracy, that evidence to indicate that there's a potential for significant adverse impact on public access to this coastline area?
I would say without direct evidence of the type of use, I would not say that there is significant impact. Could there be potential? Yes, but the citing of the design was chosen to limit that impact so that people could, whomever has a right to use this right of way, can still launch and head to the east, which would avoid the salt marsh, which is probably the way they typically would launch anyway. So it's still consistent with others that have been permitted in the past, where if the town owns the right of way, typically the town would be the one that could sign off on it.
Right, but I'm just clarifying under our rules, potential for significant adverse impact to public access, you're saying no, that is not.
I have not seen anything to say significant.
Okay, thank you.
Potential for impact.
That doesn't say that, it says potential for significant adverse, significant and adverse, and you're saying no.
Not that I've seen.
Okay.
But I have a separate issue on that matter. I think I may have misunderstood this. Is the town of South Kingston asserting an ownership interest in this right of way? Because what I'm worried about is section 8-2-14A, which, confers exclusive jurisdiction on the Superior Court to make a determination as to property interests. That was my concern. Am I misunderstanding this?
I don't believe so. From the information that I've seen on the right of way discussions, it is the town's position that, and maybe I could speak, but it is the town's position that they recognize that it's likely privately held. They actually asked for the title information that the applicant provided to us, but they recognize historical use of the area.
Is it an assertion that there is a prescriptive easement over this area?
I haven't
Is that
seen
the
any of that
assertion?
language in the town's correspondence at
No?
all.
If I may, what the town has replied to us is that they are aware of the historical regular use by the public of Water Street to access Potter Pond. They further go on to state, the town does, it is our understanding that this road is a private road and as such would require going through the CRMC process to become a designated public right of way.
Okay, so that would be a prescriptive easement if the public was using this laneway. That's the technical term for this, but the name Water Street is what's throwing me off. Was this a platted street?
I can answer that.
Right.
Yes, it was. So one of the letters that I responded to, I think it was in April of 22, it was a follow-up letter. I investigated the status of Water Street on behalf of Mr. Morgan when we looked at this issue. We concluded the town, official town record of streets and maps recognizes Water Street as a private street, paper street. There's never been an assertion by the town. In fact, I think they've admitted that it is private, and the town does not have a public interest in that roadway. They admitted that in their correspondence to the council. My research indicated, and I think I attached the original plat map to my correspondence, that Water Street was a private platted street, I think in the mid-1900s, where lots were designated. Water Street was just never included. The town had never, to my knowledge, accepted that formally, either through action or through a government action, a council action, affirmative adoption of that roadway. It's always been private, privately maintained and operated by the abutters to Water Street. Out of an abundance of caution, I am familiar with the law of incipient dedication and those who may have a right to Water Street. We included, again, out of an abundance of caution, everyone that may have a right into and over Water Street, including everybody on that plat map.
Okay, so it's a dedicated but not accepted right of way.
That's correct.
Okay. The town's never accepted it.
Not to my knowledge.
How many lots in the plat?
The original plat, it was maybe 10 or 12, but those have been shrunken into smaller lots over time. I don't think there's more than 20 total on that plat. It's limited to both sides of Water Street. There were much bigger tracts, parcels back when it was platted. So there's smaller individual lots now, but the abutters list that we included everybody that would have been on that plat.
Well, the issue as to title to the property is not to me an issue here. Because this is a what is known as, when you hear paper street, you basically have a street that was platted. The plat was recorded. That's the dedication. The town has to take an affirmative step and accept the road for it to become a public street. If members of the public have traversed on this street, they have what are known as prescriptive rights over the street, notwithstanding the fact that it's been platted in that the owners of the plat all have an interest in that lot. Because as you know, under the Lynch versus Newport Realty case, you can have adverse possession of prescriptive easements over dedicated rights of way. So, you know, I think that's what you're looking at here. And I hate to take that route and talk about the law on this thing, but it ties back to 1.1.6 as to whether or not there is a significant impact on the matter. And I think what Tracy is saying is the evidence is not quite there of the public usage. Is that correct?
Correct. As permit staff, I have not seen anything to that presented, or no one commented during the notice.
Oh, but didn't he just read? I thought you just read that there was a that is the content of the objection, is the consistent and historic public use. That wasn't what you read just now,
And that's from the town of South Kingston, correct?
right? The objector,
No. This was from the harbor master representing the town of
well,
South.
from the town,
Right.
that's the town.
I had asked him on, could the town support a public designation of Water Street? And that was his response.
So that does not count as evidence of public use?
All the harbor master said in his reply to me was they're aware of the historic regular use by the public.
We just, aren't we looking at, maybe the right of way committee ought to discuss this and then come back to us before we act on this application?
For purposes of tonight, my recommendation is going to be assume that the public has certain rights to traverse over this Water Street strip of land. The next question is whether or not the proposal has an adverse impact on the public's use of that.
And the public use, I mean, there's a difference between walking and driving cars and things like that, right? If you put a portion of this application on that street, it may preclude cars, but it probably won't preclude foot traffic.
Well, because I so very seldom get outside the East Bay, I defer to Tracy on those matters.
Whatever. Oh, poor Tracy.
Do I believe that public or private use of this easement or of this right of way could still be happening with the current proposal? Yes. The original proposal actually had it further south, east, I guess is the right direction, crossing some marsh, pushing it even further into the right of way. We actually got it moved further west and moved. I think it ended up slightly longer, but it extended, if you're looking at the plans, where it crosses the property line extension of the right of way is now further out into the water than the original proposal, giving more opportunity for people to just continue to use that right of way.
Okay.
And there are moorings, nearby. The town had no issues with anything there either.
You feel we can go forward, correct? Yes. Okay.
Thank you, Mr. Chair. Yeah, so just to add on to that, I mean, we did look into the Water Street issue, and I think the objection, the way it was characterized by the harbor master through the town council was that they wanted the council to look at the status of Water Street, where it sat on the right-of-way subcommittee, and a follow-up to an earlier inquiry that the town had made. So the town's objection is really based on a future prospective use of Water Street as a CRMC designated right-of-way, which I don't think anybody disagrees it has not been designated as such. But to the extent anybody has a right or an interest over Water Street for public access or not, we're not, suggesting that whatever the status is, this was designed in concert with staff to make sure that we've respected the rights of Water Street and anybody that may have an interest in it by increasing the length, the bend, and respecting the littoral boundaries of both Water Street and the properties to the west. So with that in mind, this was designed acknowledging that some people may have a right and an interest in and over Water Street, and this was designed to minimize any impacts to those littoral rights. And as you can see from the configuration, really there's no way to site a dock on this property based on this kitty corner lot and intersecting property projections, including Water Street. I think just briefly, I'd like to ask Russ Morgan to be sworn in and just testify briefly about the proposal and some of those changes that were made.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell it for the record.
Sure. Russ Morgan, RUSSELLMORGAN. Mr. Morgan, were you involved in the preparation of this application and the materials that were submitted? Yes. And you're familiar with 20 Water Street? Yes. Did you confirm with staff after the initial application was submitted Yes. Could you just briefly describe what the initial dock design looked like?
The initial dock design carried the fixed portion of the dock over the marsh and extended it out beyond the property lines.
Okay, and after the initial submission, did you work with staff to redesign the proposed application, the proposed dock?
Yes, we worked with staff to wrap this dock around existing wetland.
What other reasons were there for that change in the dock design, if any?
There's a couple of considerations here is keeping a safe distance from the existing dock to the east, to the west, I'm sorry. And also not really trying to block off folks who walk down Water Street and access the water.
So you incorporated, did you incorporate staff comments into the redesign?
Yes.
Is the design of the dock, did you design the dock to minimize any adverse impacts?
Yes.
And that's both environmental and to littoral rights?
And use, yes. Use of the water sheet.
Is it possible to situate a site, a dock on this property without relief from this council?
You know.
And that's with respect to the property line extensions?
Property line extension, yes.
Because of the characteristics of the property itself?
The property, the adjacent property. We cross 1, 2, 3 property line extensions.
Did you receive any letters of no objection from abutting property owners?
I did not.
Did anybody object to your knowledge that abuts Water Street?
No.
In your professional opinion, does the design conform to the goals and policies of CRMC?
I think it does.
And did you utilize best management practices in the design of the dock?
Yes.
I don't have any further questions.
Any questions of Mr. Morgan from the council?
Yeah, Mr. Chairman, Mr. Morgan has a blow up of the plan that you have in your package. It may just be useful to see the characteristics of Water Street and how it's used and how the dock is designed in such a manner to reduce the impact to potential boat launching.
Sure. When I was out there doing site measurements, somebody from the neighborhood walked down with a paddleboard, kind of watched them use this beach access here. Real shallow, it's real soft bottoms. I don't think it's going to be an area where someone tries to roll a vessel of any size. It's mostly foot traffic, I think, with kayaks or paddleboard. And we try to keep this dock kind of out of the way of that access, and that even though the property lines are here, you can kind of see that worn path is in this direction. And even though that terminal float is sitting over this extension, I was cognizant of that potential use to try to keep that float out of the way of that use and not prohibit it. Just wanted to point that out. It's really a tough site in that property lines. There's no other way to really site this thing without asking for a variance.
So you're saying that by that depiction, the path that goes down and goes to my left?
That's right. I just wanted to point that out in terms of this thought, is this dock going to prohibit use of this area? And I think just because of the way that path is formed, it doesn't. It definitely falls within that zone of property line extensions, but I don't think it really prohibits use. That's the only point I want to make.
say something.
No, all set.
Please proceed, counsel.
Nothing further, Mr. Chairman, unless there's additional questions for myself, the applicant, or Mr. Morgan. Again, with respect to the status of Water Street, I think it's really, we designed this to minimize any impacts to Water Street and the abutting property owners. And to the extent the town wants this council to review it as part of its subcommittee at a later date. There's a time and a place for that, but we're not aware of any formal designation of this as being a public right of way.
Any questions of the applicant, like the council at this time?
One question.
Yes, Mr. Gagnon.
So is there any parking on Water Street or is it just all foot traffic that accesses it?
To my knowledge, there's no parking along Water Street. There's private driveways off to the respective properties, but no parking on Water Street.
Or is there anyone else this evening to speak in favor of this application? Is there anyone present this evening to speak in opposition of this application? Tracy, any final comments?
No, the only other thing is on the photo that Russ showed, you can also see the extension of the wetland and marsh that extend probably a third of the way into, where you're first lifting from that right of way, which is probably also what drives the traffic the opposite direction.
All right. That concludes the presentation by the applicant. Is the council position for motion? Mr. Gomez.
Yeah, based on the findings of fact, discussion and a clarification on the Water Street issues and the town issues. And the fact that it appears that the Water Street extension, the dock is over part of it, but it's underwater. The extension of Water Street is underwater. I would move approval of the application.
Thank you. Is there a second? Second. Seconded by Mr. Izzy. So a motion has been made and seconded to approve. Any discussion from the council? Seeing none, I'll pull the council. Mr. Russolino. Aye. Ms. Hall.
Aye.
Mr. Gagnon.
Aye.
Mr. Izzy. Aye. Mr. Gomez.
Aye.
I too, Raymond Coyer vote aye. The application has been approved 6-0.
Thank you.
Thank you. I'm gonna take a 5-minute recess.
The mystery.
Not immediate, I couldn't press that.
Our last matter is 2020-05-083. Andrew Van Hemmelrick. It's for 2 aquaculture farm sites, 1 primary 0.55 acre site and a 0.05 acre winter storage site for the cultivation of oysters and quahogs using submerged gear in Point Judith Road, Narragansett, Rhode Island. During the break, some discussions were held with the applicant, other attorneys, and our counsel, Attorney DeSisto, and I'd ask if you could report back, sir.
There are 2 attorneys present for all of the interested parties here tonight. The first is Attorney Maureen Hobson, who entered into a mediation with the applicant. I understand that concessions were made by the applicant, and an agreement has been had, and Ms. Hobson has told me that her the group that she represents is in agreement with those concessions. However, there's another attorney here, Mark Fay. Mr. Fay tells me that he just was lately retained by his clients. It's another group down in this area, and he has an objection based on procedure, specifically notice. In a discussion with both attorneys and the applicant, because Mr. Fay's clients have not had the opportunity to see what Ms. Hobson and her clients have agreed to, the recommendation by me, and it's by agreement, is to continue the matter to the October 24th meeting. Ms. Hobson can be there, Mr. Fay can, and the applicant can be there. At that time, we can address Mr. Fay's issues if he has any. Hopefully, his group will be in agreement with Ms. Hobson, what she achieved in mediation with the applicant. So my recommendation is to continue the matter to the October 24th meeting. You do, yes.
All right. So a motion has been made by Mr. Gomez to continue the matter based on the representations made by Attorney DeSisto. Is there a second?
Second.
Seconded by Mr. Russolino as well as Mr. Gagnon concurrently. Any discussion? I will pull the council. So a motion has been made to continue the matter and seconded. Mr. Russolino.
Aye.
Ms. Hall.
Aye.
Mr. Gagnon.
Aye.
Mr. Izzy.
Aye.
Mr. Gomez.
Aye.
I too, Raymond Coyer, vote aye. And the matter will be continued. Thank you, everyone.
Maureen, thank you. Thank you.
And nothing further to come before us. I entertain a motion to adjourn. Motion made.